All right, so I see it's 3:30 now, and just being cognizant of the time, I just want to say good afternoon, everyone. Thanks for joining today's roster webinar, A Criminal Lawyer's Guide to the Tariff. So my name's Wyatt Fraser, and I'm Legal Aid Alberta's engagement facilitator. So Legal Aid Alberta works with over 1,200 roster lawyers, and you all play a critical role in helping us improve Albertans' access to justice. These webinars are intended as a way for us to reach out, engage with, and help equip and educate members of our roster so that together we can realize the vision of an Alberta where everyone can understand and protect their legal rights. During today's webinar, the way you can communicate with us is through the chat window. You're welcome to type any questions that you may have or that may come up during the webinar into the chat, and periodically throughout the presentation, we'll take time to go through and answer some of these questions. If we have time at the end of today's webinar, we'll be sure to go through any remaining questions to answer them as well. Being cognizant of the time, we may not be able to get to all questions, but we will make note of them and provide an answer via email afterwards. The chat is visible to all attendees here today, so if you have a more private question, or if you think of a question after the webinar, please feel free to email to communications@legalaid.ab.ca. Today's session is being recorded, and a copy will be available later on our website on the roster resources page. And with that quick bit of housekeeping out of the way, it's my pleasure to introduce our main speaker for today, Lindsay Hoban. Lindsay is Legal Aid Alberta's Operations and Assessment Manager of Justice Services. She has worked as a private criminal defense lawyer and was once a member of the Legal Aid roster before joining Legal Aid in 2018. And with that, I'll turn it over to you, Lindsay.
Thank you, Wyatt, and welcome everybody. Hopefully I see some familiar names, but of course, definitely put any questions in the chat. Now, my last bit of introduction or housekeeping for this purpose is that we only have an hour. We're not going to be diving into maybe some of the more particular questions that you may have. So I'm glad Wyatt noted that you can always email us for questions, and I'll give you a couple more email options for that. So this is kind of meant to be a generic type introduction. I'll go into some detail as we go along or as the questions come out, but we are looking to do a little bit more of an advanced sort of criminal billing guide, probably later in the year, and through some materials that we're going to post on the roster resources website. So with that, and sorry, my other disclaimer warning is I have a very sensitive mouse and sometimes I accidentally flip back and forth. So apologize right off the bat. For that, I'm not always the greatest with technology. The agenda for today is you're going to notice that the PowerPoint is a little bit bare bones in terms of information. We do have a tariff handbook, unofficial, so to speak, that will be sent out by email following this, and then ideally is also going to be distributed. Distribute it as far as you want. It'll have all this information written down and a little bit more. So pass it out as you know or as you need. And of course, it'll be available on our roster resources webpage soon. So I want to start with sort of understanding the tariff. This is meant to be geared towards a criminal practice. However, there's some tariff rules that just sort of stand, and we'll go through some of those. We'll zoom in on the criminal tariff, go through some common frequently asked questions, and hopefully you guys do have some that I can address as we go through. And then conclusion and materials, reminders of where you can find this, and everything that we're going to be posting as we go on. So the tariff, some of this is going to be, fairly candid, and the tariff really, as it stands now, has not changed in terms of structure or function really since about 1989. So that's really where the structure of the tariff lies. However, the issue is that it's currently tied to our governance agreement. So just to gloss over a little bit at the top, we are at the midpoint of our governance agreement with the ministry, and we are currently working on trying to work towards being able to modernize or reinvigorate sort of the structure of the tariff, because as you can see, the criminal justice system has really moved forward. At 1989, we didn't even have a lot of charter pre-motions going or anything like that, not to mention other changes to the law. So we are moving forward with redesigning or modernizing the tariff. Consultations with roster members are certainly coming up within the coming months here. But this webinar is really intended to give you a little bit of an idea of how to work with the tariff while we're kind of stuck with it. I know that's not the most professional language that I should be using, but that's where we are, and that's kind of what we're stuck with until we have a new tariff with a new structure. So the tariff, on a very general basis, operates on a half-day type basis. So again, this really, in my view, I wasn't around in 1989, of course, but ties back to just the less volume that used to exist in the courts. Obviously, population has increased, all of that. So the half-day basis that it was formulated on was, in my opinion, when docket days were actually a half day, so to speak. So you could actually go, you could get your appearance done, and you could be done somewhere before lunch. We know that these days it's not so, you rarely get that opportunity, and so you're often invoicing things on a half-day basis. This holds true, of course, for the tariffs, for the trial tariffs, which I know is a pain point. Can't wait to get those fixed in the future, because if you have a 3-week trial, that is a lot of entries. I know we have some assistants in the mix with us, and I'm preaching to the choir for all the hard work that you guys do in entering 30 half days for trial time. So aware of that, but again, kind of stuck with it for the moment. You can only charge one tariff per half day for the same client. So this really comes up if you have multiple certificates for the same client, because obviously you're a little bit at whim to our appointing rules and the way that we issue certificates. Again, that's something that we will hope to address when we reinvigorate the tariff as well. But oftentimes, just as a side note, if you can't validate your invoice, check that you haven't accidentally hit AM twice or PM twice. I've seen that a lot, and you get so cross-eyed trying to go through all of these 30 half days that sometimes these mistakes happen. But just a tip, you cannot charge, of course, for across the same certificate. So if you have a guilty plea for a client where you've got 4 certificates, that guilty plea ends up on 1 certificate, and you may use multiple charges on the remainder of these certificates if it's a global resolution. I do have a specific slide on the multiple charges issue, so just kind of a teaser at this point. The other piece to know is that system controls are in place. So on top of some of the frustrating nature of our invoicing system, we have additional system controls that are meant to implement the rules of the tariff and prevent what I call sort of inaccurate invoicing or some of these mistakes, but it honestly doesn't catch all of it. So the ones that you really need to know about are 1 outcome per 1 information. And when I go into some of the FAQs, what that really means is sometimes the difficulty in trying to bill out your certificates is that you may have accidentally clicked too many informations on 1 outcome. The system auto calculates that. So if you have 6 informations on a certificate and you accidentally attach 2 informations to 1 guilty plea, even though they happened on different days, then all of a sudden when you go to final invoice that last guilty plea for that last information, it's like, okay, why can't I validate? It's because probably somewhere along the way you've accidentally said, I resolved 2 of these instead of 1. So it's that 1 outcome per 1 information. So in terms of tips, the taxation team, of course, or the CTO team, so pressing 5 on our IVR or emailing taxation, are happy to help you through that process as well and sort of give you a second set of eyes. Sometimes it's honestly just the second set of eyes that helps to get those invoices validated. And they're really the expert on looking through those invoices, but I'm just trying to give you some general tips that I see that are common frustrations for the criminal bar. And again, the 1 tariff per half day per client. So if you've got 3 clients on obviously different certificates, you've got guilty pleas for all of them that morning, you'll have no trouble invoicing a 1.27 tariff, guilty plea tariff for each of those clients on that same morning. If it's the same client with 3 guilty pleas to 3 different informations across those certificates, you can only invoice 1 guilty plea. So those are some of the nuances, and that's the reason that I discuss some of those system controls, because oftentimes the difficulty is not that, I hate to say it, but not that what you're invoicing is wrong. It's just that somewhere along the way, it's hitting a system control that it either shouldn't, or because a small mistake may have been made on another invoice, all of a sudden now you can't final bill. So some of this is system controls that need to be replaced as we reinvigorate the tariff, and of course look to streamline our invoicing just generally to reduce some of these pain points. The criminal tariff, and this is the same for family tariff. However, my colleague Misha will be providing her own sort of deep dive into the family tariff. I believe it's at the end of February. That's on our roster webinar webpage. But what holds true is that we operate on a combination of block fees and hourly billing. So if you are familiar with other legal aid plans, this obviously stands out because it's different and slightly awkward in certain respects. So, you know, Ontario primarily operates on an hourly basis. BC primarily operates on a block fee, aside from their high cost or their sort of severe or complex cases. But the Alberta tariff, when it was developed, was a combination of block fees and then hourly billing. So hourly billing, what I'm talking about there is, of course, the additional hours, which I'll get into in more detail, but also certain tariffs like speaking to sentence that are chargeable on an hourly basis. So you have 4 hours per half day for speaking the sentence. If you spend 2 hours in prep and 2 hours in court, you charge the full 4 hours. If you charge 1 hour in prep, oh, thank you, Wyatt. It's actually this end of January. If you charge 1 hour in prep and you're in court for 1 hour, then you charge 2 hours, and that's some of the hourly billing. Why this really ties back is that, of course, when the tariff was developed in 1989, it was intended to primarily operate on those block fees. So even though additional hours were worked into our tariff, they were never really contemplated to be what they've really become. We're also looking, I know that additional hours is often a pain point for the roster as well, and I will have further webinars and materials, so I'm just going to sort of gloss over the top. But the handbook that I'm sending out has a lot more detail that I just was worried I wouldn't get to today, so just kind of a heads up on that. But in 1989, it was easy to do a block fee for a guilty plea. In fact, if any of you in the audience have been around long enough, you may remember the days of paper billing with legal aid, where there was actually express billing that you could do, and that was the ultimate kind of block fee. So you actually took a little bit of a ding in terms of the number of hours that you could spend in the file in order to be express paid. So the reason I bring this up, of course, is that you can see how the criminal tariff really hasn't kept pace with the criminal justice system or the times, because the block fees which are set within our governance agreement. So there's no way for us to actually restructure that tariff. That's why reinvigorating the tariff is such a huge project and will, you know, involve some consultation, and we want to do it right the first time and have, you know, a better tariff moving forward. But it really didn't contemplate a lot of this hourly billing. And when we get into situations like we are now, where we've got longer trials, more pretrial motions, you know, more law to sort of get through the charter or otherwise, hourly billing and additional hours becomes far more important than it used to be in 1989 or even, you know, early into the 90s and things like that. And it's really become a beast in the way that it interacts with the tariff and has caused some confusion. Primarily, this is why one of the goals today is to try and sort of get rid of some of that confusion that exists. So the block fees exist. They used to just be one and done. Hourly billing within the tariff also exists, but of course the additional hours that were built in were never really intended to do or operate how they operate now. You can also see that in the way that the tariffs are characterized. So these are my words, you won't find these as an official interpretation, but we kind of have a combination of process tariffs and outcome tariffs. So I'm just going to flip to the next slide for a moment and give you just kind of a brief overview, but you'll probably recognize this. You know, we have this out of the block fees and the combination with hourly billing, which is a little bit wonky already. We have this other sort of process-based tariff. So you're being paid or you're invoicing legal aid based on steps of the files. And these steps, as they were outlined in 1989, were meant to be inclusive of all preparation, all attendance. That's why I say, of course, it hasn't kept pace and additional hours come into play. But our interviewing and briefing, our adjournments, the pretrial conferences and things like that, those are all sorts of process tariffs. They are either block fee or potentially hourly, depending. So for example, waiving out of jurisdiction is an hourly block rate up to 2 hours, depending on what you need to do in that situation. The outcome tariffs, again, are typically block fees, except for what you see for speaking to sentence, and even counsel withdrawing from the record, which is up to 2 hours. You could charge 1 hour, you could charge 2. Again, harken back to my speaking to sentence sort of example. But these process tariffs and these outcome tariffs are some of the best ways to kind of understand or differentiate how the tariff kind of operates. And you can see probably when we phrase it a little bit this way, how it really hasn't kept pace, again, with the criminal justice system, and that there's a lot more process and procedure in the criminal justice system than there was in 1989 for one reason or another. Trials are longer, everything like that. But it's a good way to look. So, you know, when I'm invoicing or when I'm understanding the tariff and what's included, each of these block fees, so to speak, leaving aside the hourly ones, include preparation and attendance. So in the tariff creator's mind, back again in 1989, it was, yeah, I can just hit interviewing and briefing, I'll do a couple adjournments, I'll get my trial tariff done, and I'm done. And everything's included in that. We know, obviously, that it's not as simple as that. So while the block fees are intended to be inclusive of preparation and attendance, we rely on additional hours to cover or compensate for additional preparation that is needed. Hourly fees then come into play. So all of a sudden you've jumped from kind of an invoice that's just a set of block fees to hourly invoicing, which is an actual time estimate. And that's where our timesheets come in. Again, I'm glossing over at the moment, but we'll go into it a little bit further into the presentation. But it's essential to understand the tariff. Why I'm starting so generally and probably a bit boring, because you might already know this, is it's essential to understand how that tariff is set up so that you can understand how to request additional hours when you need them, what's appropriate to request, and how to request those, of course. Additional hours per our tariff rules are only justified where tariff included hours have been or will be expended. So again, we obviously want to be as discretionary as we can, because the tariff wasn't designed to be 30 years in the future and sort of encompass some of the odd situations that we have now. But we're still, I guess my point here is I'm still tied by the rules that we are within our governance agreement and within the tariff, which operates kind of as legal aids law. So there is only sometimes so much that we can do in terms of getting around some of those block fees in the tariff, but obviously we do try and do what we can, because we recognize that the tariff hasn't kept pace with the criminal justice system. Going back to the what is preparation and what is attendance. So the general rule, and again, this is all in the handbook laid out, so I'm going to go over it fairly quickly, but in 1989, it was assumed that you had 3 hours of court time per half day. So if you're looking, for example, and I know I can't highlight, but a guilty plea on the day of trial, so that would be for the first half day. If you divide the the block fee by the hourly rate, which is currently $92.40, you get 5.48 hours. Now, this includes, again, preparation and attendance. So if you go in to do the guilty plea and it takes you 4 hours to get it done that morning of trial, you only have 1.48 hours in terms of what you needed to prep. I mean, those would be an inclusive sort of situation, so maybe not the best example. But a guilty plea is another one. So it assumes 1 hour of court time and then 2 hours of preparation. So when you're looking at, okay, what included hours are there in the tariff, you have to sort of draw back to some of these assumptions. And again, it's all available in the handbook, but it's, you know, a guilty plea is assumed to be basically 1 hour. So we presume that the remainder of the included time would be preparation time. Now, of course, not every guilty plea is a joint submission and not every guilty plea is cut and dry. So that's, you know, where we start to get into some of those difficulties of, you know, the fee is certainly not inclusive of all the work that I needed to do. So I need to get into some additional hours. My point here is that you always want to make sure that the included hours are accounted for. So if you're writing an additional hours request and you're saying I need 5 hours to interview with my client or prepare them to testimony, the best way to ensure that you get those hours approved, because that is certainly reasonable and justifiable, is to say, I've used up my interviewing and briefing time. So whether that was in preparation for, that's kind of a loan block fee, but whether that was the initial meetings or whatnot. So it always ties back to the tariff. And this might sound a little bit annoying, and I know that it's annoying and it's a bit of a pain point, but the bottom line, unfortunately, is that legal aid is a publicly funded organization. And so every expenditure of funds needs to be justified back to our public funder. And that's why we've taken a bit of that harder line on what documentation that we need. The second piece of it is that as we look to reinvigorate the tariff, of course, I want to be prepared for making sure that the new block fees or hourly or whichever direction we end up going includes everything that we need. So of course that'll come out in consultation, but some of the data certainly tells us. I mean, it's easy, for example, to see that the pretrial motions in a sexual assault case typically take a certain range of hours. And while you're stuck right now requesting them, we would obviously hope with the new version of the tariff and that process that it would be included so that you don't have to take some of that administrative time to actually request hours that are clearly needed. So it's a balance of, you can use these sort of guidelines generally and sort of say, okay, well, look, one of the most important ones is the half day or full day trial. So again, we're back to the half day sort of issue. And you can see that the half day, so the first half day, the way that the tariff is currently structured assumes that trials typically don't last longer than 1 day. So you get all of this prep time attached to your first half day, and then you basically get nothing for the remainder of the half days. You're only paid for your court time. The breakdown actually of the block fee for 1.25 or 1.25 is, I think it's 3.03 hours or something. So literally just the court time, none of that preparation time. So that's another thing to take into account when you're requesting those additional hours is, it's certainly, we understand that further hours are going to be needed, that 3 hours or just under 3 hours is not going to be enough prep time for trials in most cases. But that's what we're sort of going with. And the truth is, if it's a low level matter or you can't articulate a reason why the 3 hours aren't enough, you will probably find that your request will be rejected or rejected asking for more information, because you'll hear the phrase tariff included being bounced around quite a bit. And that's what we're sort of talking about. So I know this is a lot to take in. Don't screen. The handbook will have all of this laid out plus more. And then you can always reference that back when you're making those additional hour requests, or just generally when you're timekeeping within your firms or for your lawyers. So getting into our common FAQ, so to speak, and there's always a lot. And at this point, if you want to start typing in questions, if you do have any, or this is sort of the what happens in this, go for it. I'm keeping an eye out, and I've got Wyatt to assist me, of course. The adjournments, I'm going to give you a bit of information on each of these, and then I recognize, of course, that even though my purpose is not to discuss the invoicing system in particular, some of these pain points obviously tie back to the invoicing system. So I'm going to try and give you as much information, my goal being to give you as much information as I can to prevent sort of the frustration at billing time and understanding, how this tariff works or how to bill it. So adjournments are a common issue, and they're an issue for sort of two reasons. One, we only have join to sort of confirm these adjournments. If we do want to fact check or line check an invoice for any reason, it's only join. And we know, and we've constantly heard from you guys that join really, it was never good, but it's certainly getting worse in terms of the amount of information that's captured and the accuracy of that information. So for a good amount of time, what happened, there was a lot of confusion between Tariff 110 and 111. So I've just put the information up here about the 111, but 110 is, of course, your adjournment in docket court, and 111 is your adjournment not in docket court. Currently, the 111s are being pulled for what we call manual review. So if you're submitting an invoice that has a 1.11 on it, it will go into that in review pile and be reviewed by a taxation officer. I do promise you that we're currently working on that manual review and looking at what we're pulling for manual review and whether it's appropriate or not. We're looking to really also reinvigorate that invoicing process before the end of March. And I'm really putting this on the record because it is such an important next step. You know, it's not just understanding the tariff, it's also how the tariff operates practically for you guys, and the ever sort of dangerous question of, will my invoice be validated? So sorry, harkening back to that, currently the 111 is being pulled for manual review. And the reason is that there is still a little bit of confusion about, do I invoice a 110 or do I invoice a 111? Again, the 110 is only 46.20 or something along that, basically half of your hourly rate. And we know, again, that that hasn't really kept pace with the criminal justice system, and possibly, especially during COVID, the amount of work that you're putting in to the adjournments. However, we, on the other hand, are stuck with the idea of legal aid cannot sort of pay everybody for every hour that they spend sort of waiting in court. It's something that we're going to have to address in the new tariff, but recognize that unfortunately, that fee or that block fee for the adjournment is a bit low, and people tend to look at the 111, and that's really why it went into manual review, is that it was being used unfortunately inappropriately. And so you cannot charge this if you've had to wait in docket court for a long time, even though that happens, I understand. For arraignments in QB are 1.20, by the way. You can use that for every arraignment, except for bail hearings, which are 1.08, 1.09. I don't mean to be disrespectful in you feel the adjournment was more work. I absolutely sympathize that the 46.20 is often not appropriate. However, it is one of those situations where I can't add additional hours. I don't have that discretion. It's not really the appropriate use of the additional hours, and it's unfortunately one of those situations where you are taking sort of that hit on the adjournment. The best thing that I can say is, until we get a new tariff, as much as you can, try and obviously prevent those adjournments from piling up. But sometimes that's simply impossible. I can't say that in this presentation I'm going to have the best answer for everything, but I'm certainly going to be candid and honest with you guys in terms of what I'm seeing. I've directed the taxation team to see whether a date has been scheduled in order to assess whether that tariff is appropriate. So while we work on renewing our manual review policies or procedures, I've given them clear direction to simply check basically where a date is scheduled. We're also pushing very hard, again, for them to reach out to council if there's confusion prior to rejecting your invoice. We want to reject less invoices. So if you get an email from our taxation team, again, it's not meant to be accusatory. I apologize if sometimes the language is not the best, or, you know, sometimes these taxation officers, I can tell you, they're working through hundreds of invoices on a monthly basis. That's one of the reasons that we want to reduce the volume that they have to manually review. And I don't mean to make excuses, but it also explains sometimes why you might find it a little bit kind of an off the cuff email, or maybe something else gets missed in your invoicing. So setting a date, the other thing is that setting a date or your first appearance are not chargeable under either adjournment. So these again are the tariff rules. I've got it slightly laid out more in the handbook, but these adjournments always come up as an issue, and they often cause a lot of back and forth between the taxation officers and the roster. 1.37, speaking of other beasts of the tariff, so to speak, is the multiple charges. The first problem is that it's termed multiple charges when it really should be multiple informations, because realistically, you can only use it when you are globally resolving more than one information. So again, this can be across certificates or within the same certificate, but it's only when these matters are being resolved the original intention of 1.37 was to, sorry, Sinclair, I see your question. I'm just going to finish my thought and I'll circle back around. The original intention of this tariff was to compensate for additional disclosure review for each additional information that you resolve. So it almost imagines that you're resolving one substantive matter and then you just have a bunch of fail to appears that take, you know, an hour or less to prepare for that guilty plea. Of course, that's not always the situation. And so you not only need to take into account the tariff included hours, but the multiple charges included hours as well. It's basically 1 additional hour for every additional information that is resolved. It's currently coming out for manual review as well. And that is because there's a couple situations where it's not clear that you're not able to charge. So for when billing for a change of counsel or when billing for withdrawal from the record. And unfortunately, this is another situation where it gets a little bit concerning because oftentimes you may not request additional hours because you anticipated that you were going to be covered within your 3-hour time for the trial. But then suddenly the client disappears. At that point, what you've got to ask yourself is, look, I can bill up to 2 hours for the withdrawal. Depending on the situation, maybe I've only spent an hour in preparation so far before I lost track of the client. Technically, then you can be covered within these 2 hours. Of course, if it's a lot closer to trial, sometimes you spent more preparation hours. The best thing that I can say is that we are cognizant of those exceptional circumstances, and as much as we can, make the authorization request and explain the situation, and we will do our best to accommodate where we can within of course, our policies and rules. Yes, and so the implement a notification to email, yes. So for the portal, currently the lawyer portal, and I'll try not to digress too far, but the lawyer portal certainly doesn't have the best notification type system, especially in terms of invoicing. And when you suddenly get that shock of my invoice has been rejected and I didn't realize, and now I'm another pay period ahead. So to that point, I'm encouraging the CTO teams, and we're working with the management and everybody to reduce the amount of rejections and try and solve this problem up front with an email. So instead of working through the lawyer portal, so to speak, we're going to try and connect with you more one-on-one. However, I do agree with you that that notification system needs to be made better, and it's certainly something that we're exploring on the lawyer portal side, a little bit outside of this, but it's a great point to raise. We often hear that feedback that you just don't get the notification, you have busy practices, you haven't been able to sign in, and all of a sudden you find yourself kind of behind the game. With additional hours, you can obviously also always make the request if something's fallen through, you forgot to hit submit, and the same holds true for the invoices. But of course, the difficulty there on your end of things is that if you don't notice right away, then again, you fall behind in those pay periods. So I appreciate you bringing it up, and it's certainly something that we'll look into, and I would hope to provide some good news shortly that something will kick out and give you an idea. Transcripts. Transcripts come up quite a bit in terms of questions, just because the tariff isn't the most clear in terms of what falls under 811 and what's a special type of disbursement. So just to be clear, this is again in the handbook, the 811 is any non-expedited transcript. So anything ordered basically on a 30-day turnaround, whether that's prelim transcripts, whether that's hearing transcripts or other sorts of things, you can charge under 811 without having prior approval. It's an actual cost. Just make sure that you attach the invoice, of course, from TMS. I'm sure those of you have heard as well that there is a new TMS system sort of coming. Again, I digress, I apologize, but continue to attach those invoices. We don't have any access, so we rely on the invoices that you attach to sort of push through that approval. If it's a bail transcript, this is where 811 comes into play, is that if you need a bail transcript on a 2-day, 5-day turnaround, again, you can charge it under 811 without prior approval. Sometimes because of the way the tariff is worded, this gets confused. So it's like, where do I fit this? And you'll make the request under 9.09, and we're going to tell you to go back and put it under 811 because that's where it properly belongs. If it's anything outside of an expedited bail transcript, anything that's ordered on a 2, 5, 10-day turnaround, it is going to go, it A, needs prior approval, and B, needs to be manually added to your certificate through an authorization request. So just as a sort of side note, the reason that we have the authorization request system into play is not only to sort of track approvals and things, but it actually, each certificate that's issued to you is manually collaborated, so to speak, and then pushed out to you. So when you put an authorization request in, we're amending the certificate, so to speak, and that's why we're often pushing back and saying, please go through the authorization request system, because that's how we get these amendments sort of done. Always explain. The other side of this becomes sometimes, and I know that it's frustrating, it's a documentation issue, but even if it's clear on its absolute face why something is needed, why an expert is needed, why a transcript is needed, please still provide us that reasoning in that authorization request, because it really just comes down to justifying the expenditure of those funds and making sure that we have appropriate documentation so that I can stand up and say, this was an appropriate expense and here's why. Of course, everything's collected on a confidential basis. It's not like the government's reviewing this, but the point being that we need to make sure that we're backed up in documentation as well. Another common one is experts. Experts, again, have to be approved in advance. So these are tariffs 9.01 and 9.02. 9.01 is for your report writing, so to speak, and technically 9.02 is when you require that expert to potentially testify. You'll see a difference in the authorization request because 9.02 will include a field for your expert's travel expenses. So of course, accommodation and things like that. That would be sort of those travel expenses, and everything is paid generally, aside from accommodation, of course, is paid on an hourly rate. So whether they're working on the report or they're testifying, these are the hourly rates that they are subject to. Another heads up, of course, as you probably recognize, these have not kept pace either with the current rate of our experts, and often that creates some difficulty in ensuring that you get the experts that you need to do the work for your clients. Email us, put in the authorization request. We'll give you as much direction as we can. Sometimes the only way to do it is through an order from the court. We have precedents and things like that available to help you out and can sort of do a little bit of guidance there if we fall outside of our discretion. So basically, a registered psychologist at $155 an hour, not great. A lot of our experts, we've been lucky over the years, have been willing to work within our hourly rates. I'm certainly pushing generally that these rates need to, again, keep pace with the current situation in the criminal justice system, and they haven't. For example, the other experts, professionals or investigators at $115 an hour. We often experience, DNA consultants and things like that fall into this other expert, and it becomes very difficult in a lot of ways. So work with us. In certain cases, we may direct you to go and get a court order. It's not totally unheard of. We'll help you through the process, but it is on an hourly basis. So my report writer needs 20 hours at the approvable hourly rate to write this report of whatever nature. We will approve it as long as there's no issues basically with the hourly rate. And of course that the hours seem to be within a reasonable time frame, but each case is different. My point being that if somebody, there's not a big difference maybe between 30 or 40 hours, but if you request 200 or 300 hours for report writing, unless it's an extreme complex case, it might be, we might have a little bit more questions. You also always attach a quote to show us sort of that the expert has accepted the hourly rate, whatever it may be, depending on their expertise. And then I can tell you, we actually had a situation today that once we've approved the expert for the number of hours that they've estimated, we absolutely understand that there could be things that come up. I mean, you're dealing with complex cases. So if your expert comes back with an invoice that is higher than you expected, or maybe not expected, but was previously approved for, all you need to do is submit another authorization request. We draw back to that previous approval. We're not going to say, you know, you pay it out of pocket because that's all that we approved or that's what the expert estimated. So of course, I bring it up because it just happened to come up today, but don't make that mistake. Put through that authorization request. We can amend. Oftentimes, we're lucky with you guys that you put in your request and say, my expert thinks it's going to take longer than I originally asked for. Again, we will continue. If the expert is needed, we want our legal aid clients and you to have access to the expert. So certainly work with us. One note for the invoicing side of things and some of the rejection of the billing is the GST. So the way that the system operates is actually it auto calculates the GST. So when you're in the authorization request, there's a little button that says GST exempt. So if you're working now, without going into tons of detail, because I know I'm also running out of some time, but if your invoice from your expert does not include GST, you need to check that GST exempt button. Otherwise, it'll auto calculate and then try to pay you out GST when it may not be appropriate. For that reason, this also gets pulled into manual review because we have a lot of sort of concerns with this. It's mostly system control issues is why we pull it in, but sometimes, of course, there's mistakes that may be entered. Invoices don't kind of match up, or the way that the GST is calculating is a bit odd. I've seen this come up in terms of experts from other provinces as well. So in many ways, we may use that GST exempt, or you may be directed to use that in certain ways that may not coincide exactly with the expert being GST exempt, but it's again that system control, and we're going to do what we can to work around it, or not work around it, sorry, but make sure that your expert's invoice is paid properly and GST or not, or whatever other sort of tax. Other than that, sorry, common FAQs. So I know the additional hours there's a lot more information in the handbook that's going to come out, and we'll continually update it. I've addressed a lot of these points sort of already, but the additional hours are necessary in a lot of cases. We understand that. It's a back and forth in terms of you need to be cognizant of what's included in those tariff block fees and ensuring that that is done or expended or will be expended before you move into additional hours. Secondly, it is best practice, of course, to record your time. So in any type of hourly billing, you want to record each hour as you're spending it, and that also will be required for additional requests for hours. So if you come in and say, I have 10 hours, or please, 10 hours for trial prep, and then you come back for a second request, you'll probably notice that one of my team will say, please provide your timesheets. To justify, again, that documentation and that hours are being properly expended, reasonably expended, and it's all justifiable, sort of a holistic view. This isn't the most favorite phrase of my colleagues. I know that additional hours are not guaranteed on any file, but I say it again and I hold true to it because it is a matter of providing that proper justification, of providing that proper documentation. And unfortunately, if that's not provided, or if something else exceptional comes up, additional hours may not be approved or may not be warranted in the circumstances. So again, my team works hard to try and encompass exceptional circumstances and things, but there are certain situations where we cannot extend that discretion. It's just not allowable within our current governance structure. Oh, questions. I see Ron just popped one in. I can certainly agents. Yes, so agents. Okay, one quick question. Okay, so I don't know if that's John or one of your colleagues, but the agents. So currently, we have been directing the taxation officers not to reject if you make the mistake of charging under 110 instead of 8.14 with the agent. I've made some changes as well in terms of it should only pull for manual review if you're charging for an agent above 92.40, but I do understand and I see that there's still some pain points here. we are readdressing that issue because to exactly that point, when you've got members of the same firm, it doesn't make sense that the tariff kind of ties our hands down. But the reality is we're fighting with you over, you know, $46 or $92. Firms with, and then so Ron, type in your question whenever you go. Firms with multiple lawyers, they cannot bill parking or mileage on a file. Will this change sometimes? Interesting. Okay, you know, again, too, I don't know if it's John or I'm not familiar with that. That doesn't, I mean, you're obviously entitled, like, so whether it's you who's primary counsel on the certificate or your colleague that goes to bill parking or mileage, maybe there was some sort of exceptional circumstance, but I worry that there was some sort of, well, yeah, I know, that's what I'm thinking as well, and that shouldn't be the case. So if you can shoot me an email, if you've got my email, I'll type it in. Wyatt, can you type it in the chat if you don't mind? Shoot me an email so that I can investigate. And I certainly would appreciate looking into that. Thanks, Wyatt. Okay, so yeah, I will certainly look into that. Ron's question, what happens if I was denied extra hours in September and exhausted the hours granted for trial in October was adjourned? So Ron, if that's the circumstance, this is also in the handbook, so I'll get a little bit into the sort of retroactive hours question. The truth is that it is incumbent upon you to keep your administrative files straight, to request hours as you're coming up. I know that that's not always the case, and I know that I'm preaching to the choir in terms of busy practices and things falling through the cracks or accidentally happening. Basically, in order for us to consider a request such as that, we would look at, please provide us your timesheets and an explanation of basically why you didn't have a chance to put in that extra request for hours. The really sort of, we'll take it on a case by case exception basis. However, truthfully speaking, if the first set of hours is approved in, let's say, January of last year, and it was 20 hours, and then you've completed all the way through and the file finally concludes this year in January, and you went 60 hours, I will be honest that the question will be, well, in those 8 months of time, why didn't you request more hours or kind of make sure that your file was up to date? So it is discretionary, it is case by case, but you can make that request with the timesheets to support that documentation, and my team will assess it. If there's any disagreement, you always have the option of appealing to the manager, which is myself, and I can always take another look, but I can advise you that don't be afraid to sort of write back to Katie or Matt, provide extra information or have that conversation with them. They really have the discretion, to accept things on that case by case basis. So for David, could I explain when multiple tariff items can be billed when multiple things appear in court or occur in a single court appearance? So this is certainly a difficulty with the system controls within basically our invoicing system, is because the way that the system calculates the outcome or adds up the outcome, you're exactly right. It's not only hitting the first problem, which is one tariff per half day, but it's hitting the second problem of you can't bill more than one outcome tariff per half day as well. This also, just to sort of broaden our horizons, this also comes up a lot in situations where, say, you have a trial that ended in a mistrial, and then the Crown agrees to your very reasonable resolution position and you get a guilty plea entered before a new trial begins. You're going to find that when you try and invoice that, you can't, because it's two outcomes for the same information, and that's where the system is catching up. So for David, for those types of situations, if you have, I've also seen it where a bail hearing happens, you get denied, of course, and then you end up resolving that same morning. In a lot of respects, the taxation team will tell you to do an AM and PM. So that's one way. If you've got multiple things happening in the single court appearance, do the AM and PM. So AM is the bail hearing, PM is the guilty plea, and you should be able to get the invoice through there. If there's a additional issue within the system you still can't validate for some reason, reach out to taxation. It might be a situation where we have to give additional hours to compensate for that tariff block fee that cannot be charged because of a system control or some other issue that's coming up. So certainly reach out to us. You know, don't struggle with the system. It's often a matter of bouncing that AM or PM, or we have had situations where, you know, I've had to approve 3 additional hours for a guilty plea because the first trial ended in a mistrial. So you've charged all those trial tariffs and then suddenly you can't actually final invoice. So the taxation team is sort of the go-to for that. Sorry, I'll flip my switch here. I put it on the first one. It's taxation@legalaid.ab.ca. We've got a roster resources webpage as well. The handbook distribute. My many good colleagues hopefully have already sent it out, or it'll be coming out shortly. We're going to email you a copy. The handbook has a bit more information, just in terms of I went into a couple things about QB bail and things like that. So it's also got a lot more information on the additional hours and the timesheets as well. And hopefully you will all stay tuned for the next reiteration of the webinar, which should be probably sometime within the next 6 months, where I'll do a little bit more of a focus on some of these additional hours. I'm constantly collecting your feedback as well. So if you're not sure and you're assuming that it's a no, again, the best thing to do is reach out to us. You know, there's never a harm in asking. And if we can do it, we will. So Molly, talk a bit about unique appearances. Told to fill it under the first half day of trial. So this is again one of those unfortunate difficulties where we have to go 2 ways. So any type of pre-trial motion of any variety, the trial tariff is the only type of evidence called hearing that we have. So what they basically say is, you know, when that pretrial motion starts, you start with the first day, half day of trial, and you continue all the way through. So unfortunately, the direction that you were given, Molly, was likely correct. However, the first half day in a lot of respects probably didn't cover you anyway. So I would certainly say reach out to us, and we will, for those very exceptional circumstances, that is something that we can approve through the additional hours, because the tariff just simply can't encompass it. It just doesn't. There's no way around it aside from additional hours. This holds true for those of you that are doing day-long bail hearings and things of that nature as well. So if you've got that a murder file, maybe not a murder file, it could be any file, and you are sort of going through a full day bail hearing, there is no ability, it's not a trial, and there's no ability for the tariff to properly compensate you. That's something that's got to go through the additional hours. And while we typically say additional hours are not meant for court time, the tariff just doesn't have enough options to cover all of these, and it is something we will do through additional hours. So certainly reach out to us, Molly, and we'll make sure that that you've got what you need in terms of those preparation and court hours, and that we're not sort of causing you trouble down the line, which is some of these difficulties with the tariff and the system controls. So Caitlin, so I can tell you that, well, it's recorded now, it's out there. So join, the system control is the issue. Ideally speaking, it's built in the very base of the system, of our CRM system, our client record management, and the lawyer portal. So while it would be absolutely easy to change that and say, you know what, let me charge the bail and the guilty plea hearing on the same half day, it's actually not easy in terms of redoing the system. The entire system would have to be done. So that's why we're saying, so first of all, join, if it is checked, it's going to check that both steps were taken, but even the taxation officer would tell you, or should tell you, to go AM and PM. If you do see something that is, again, rejected unnecessarily, that's something that we're really working hard to stop that process, because even to that point, Caitlin, Join doesn't actually accurately, in a lot of ways, give us that information as well. So if you've got a problem with it being rejected, always reach out to taxation. I'm always available to you as well if you have any sort of ulterior. I know I'm not supposed to give out my personal email for those reasons, but you're always welcome to reach out to me if it's something weird, and I can always help and assist on the back end. Sometimes we've seen some really weird system issues come up, and you don't know until you hit that case, and all of a sudden it's like the system's blown up for you. Bail-only certificates. So bail-only certificates are a constant struggle because I absolutely agree with you that in a lot of ways, the bail-only certificates are tied to, you know, what's going to happen in court that day, and they are only basically 2-hour certificates. So there's one side of this. One problem with the bail-only is that they should really only be used when the client does not meet our financial eligibility guidelines. But every now and again, so meaning that they wouldn't be eligible for a representation certificate anyway. However, sometimes the bail-only certificates are being issued in weird situations where the client may be actually waiting for a different process to finish, such as the DC triage or discretionary coverage. Where they're being issued because their court date is right now, we give them a bail-only certificate to at least try and get you some legal representation. But I agree with you that it is in the client's best interest, and typically we would look to deal with that where we can with additional hours. Now, it doesn't always work because, again, we run into the eligibility issue. So technically, per our rules, per our mandate, a bail only is issued in situations where they're not going to be eligible for further representation. And so it's a constant kind of balance. But if you're finding that, certificate management at legalaid.ab.ca is your go-to to inquire about getting those additional hours, or further to investigate whether that client really should have had a full representation certificate for one reason or another. Again, if something very weird happens, you're always welcome to reach out to me as well, and I can dig into the matter. Yes, so Bev, absolutely agree with you that it's difficult with the adjournments because, again, some of the court process and things and sort of the rigmarole that you have to go through is very frustrating, and you're not being properly compensated necessarily for it under 110, 111, or 120. In 120, again, I've heard some of this as well with the QBAC appearances taking a half day or more. If they take more than a half day, you can charge waiting time in the morning. So that's 1.13 up to 2 hours for the AM, and then 1.20 for the PM. That doesn't get you all the way in terms of getting all of your minutes or hours covered, but it'll get you part of the way. If it's within that same half day, my best suggestion is to reach out to us through the authorization request system on an exceptional basis and see if we can justify some additional hours. You know, again, not to pay for every hour spent, but to try and compensate for some of those tricky situations where the tariff simply can't cover us. So the,
just to chime in, probably about one more question, but again, you guys are welcome to keep asking questions because we'll take note of them and then we can respond in email afterwards. But just being aware at the time, maybe if you can answer Jonathan's question, then we can wrap up.
Absolutely. This is the tough one. So, you know, the additional hours question back and forth is you are basically requesting additional hours on what you see in the file at that time. So I know this gets a little bit nebulous. Again, welcome to reach out to me because I probably won't give you the best answer, but when you get that, that's why we give hours in chunks and as the file evolves, is because ideally, yes, it's before you work the additional hours, it has to be. Otherwise, you fall into the retroactive hours situation and we may not be able to approve those hours, which is why we say that additional hours are not guaranteed. So you do not want to wait in the back end. The truth is that if you give us a reasonable estimate of a legal issue and how much time it's going to take, we can approve those hours. You keep timesheets and you bill actual time. So if you get approved for 20 hours and you end up only needing 3 of those hours because the file evolved in a different direction, so be it. However, if the file evolves in further different direction and you end up needing more than those 20 hours, you need to come back and say, you know what, the 20 hour, it's not even that the 20 hours was too low. It's new information, new disclosure, new evolution. I need more hours. Those hours have been expended or will be expended. So avoid the retroactive. I'm not saying come in with an estimate on every one of your cases and say, I need 30 hours for this. We do check join. We do validate that. We are encouraging hours as the file evolves. And for that reason, it's because of the sort of oversight and our requirement to ensure that hours are expendable or expended on a reasonable basis as the file evolves. So I know it's not the easiest process. Again, in the future with a new tariff, we're certainly going to not only incorporate additional hours, but really redo how this administrative stuff is working. But it is a before you work the additional hours. Otherwise, you'll find yourself in a situation where we say, you should have come to us and asked for something. That's because of the admin policy 5 and our retroactive hours policy. So we are not an hourly basis. I know we're at 430, but just to reiterate, again, unfortunately, unlike Ontario, we are not an hourly tariff. And so there is no ability to do the hours and come back for payment after the fact. So be aware of that, of course.
Perfect. Thanks, Lindsay. And with that, we just want to thank everyone for attending today's webinar and for all the great questions. We'll be emailing all attendees a quick anonymous survey for us to gather some feedback about this session. And the feedback will help us plan for future sessions. The handbook that Lindsay's been mentioning throughout her presentation will also be included in the survey email, so keep an eye out for that because that should go later this afternoon. Once again, thank you for joining us. We look forward to you joining us at a future roster webinar, and please have a fantastic evening, everyone.
Thank you.